Good afternoon, everyone, and welcome to this event on using strategic litigation to end statelessness in Europe. My name is Chris Nash, and I'm the director of the European Network on Statelessness. And we're hugely excited to have had 325 people register for today's event, which I think is testament to growing awareness and determination to address statelessness. And building alliances and catalyzing action was very much one of the key objectives which we set ourselves when I and a few others founded ENS back in 2012. And since then, we've attracted over 170 members in 41 European countries, including NGOs, community representatives, lawyers, academics, and other experts committed to tackling statelessness. From the outset, we've always prioritized strategic litigation, as we very much recognize that part of the fight to end statelessness must happen through the courts. But as many of you will well know, strategic litigation takes time, and it's also inherently unpredictable and resource intensive. Therefore, back in 2019, while evaluating our progress, we had a conversation with our members about what we could do to help strengthen and accelerate our efforts. And what they told us was that a major obstacle they were experiencing was the lack of a central repository of jurisprudence from across Europe to support and stimulate their strategic litigation work. This led us to develop our Statelessness Case Law Database, which we're incredibly excited to be launching today. I really am so proud of the tireless work done by my team, supported by our members and partners across Europe, to turn this concept into a reality, and particularly to acknowledge the really important role played by our legal bureau, Patricia, and our comms bureau, Jan, as well as expert consultancy support we had from our member, Katja Spider. What I want to do now is, before we start the debate with our speakers, we're going to screen a short video which hears from some of our members and partners about why they got involved with the project and what we're trying to achieve together. So we'll screen that video now.
Statelessness is really an inhumane situation to be in.
They feel like they're frozen in time.
Have no rights in the country they are based in.
It means rejection and hopelessness.
The lack of a right to have rights.
It's important that this phenomenon is ended.
It really undermines the basic fabric of what human rights are supposed to be all about.
We prioritize working constructively with governments, doing evidence-based advocacy to bring about reform, but we also recognize that part of the fight to end statelessness has to happen through the courts.
A European-wide strategy is particularly important, not just for the individuals who are stateless, but also for the lawyers.
It's important because it sends a message that these are rights holders and people who are subjects of the law.
The Statelessness Case Law Database is going to be a crucial cog in our strategic litigation strategy.
Achieving justice in the case of one person leads to better access to rights for everyone.
As a researcher, it is very important because you can actually check what is being done in different countries, different contexts.
It brings together that kind of expertise, that kind of coordinated approach.
The value that I see in the litigation database, indeed like a knowledge hub, where specifically lawyers can see, okay, this is usually what the judges say in the Netherlands versus Poland.
It's really important to produce public goods like this that will help to catalyze additional work without having already resource-strapped NGOs having to do the same work over and over again.
It shows how people work in other countries. It shows how things can be changed, and it's a great way to learn from each other and to exchange experience.
there's a real value in comparing what's happening in one country with another.
It's an essential thing to share know-how and to share information and to share cases that were won.
It would help practitioners be able to flag potentially more quickly that this might be a statelessness case.
Tools like this database that are diverse and cross-cutting is really the next stage of advocacy around the eradication of statelessness.
I would like to see a world where stateless people are identified and their rights are protected and they're given a route to citizenship so that they can enjoy the rights you and I to take for granted.
What I would definitely hope for is that those who remain stateless in Europe see that there is a light at the end of the tunnel within their own lifetimes, not for the next generation, but for themselves.
Hopefully some of you have already had a chance to play around with the database, but if not, do take a moment to do so after the event finishes today. In a nutshell, it's a free online resource containing jurisprudence from jurisdictions across the regions, as well as from the European Court of Human Rights, the CJEU, and also the UN Human Rights Treaty bodies. It's got multiple functionality and it's searchable, for example, by country, international instrument, theme, and also keywords. It currently has over 180 case summaries. And the other thing to emphasize is that it's very much an organic tool which we plan to develop with our members and partners over the coming years through their contribution of case summaries and other support. And in that regard, I particularly want to acknowledge the importance of pro bono partnerships we've established with several international law firms, including Akin Gump, Freshfields, Hogan Lovells, Skadden, DAC Beechcroft, and DLA Piper. And these partnerships are incredibly important to us. I'd now like to ask all speakers to turn on their cameras so that we can start our online debate. I think it's fair to say that we consider ourselves hugely lucky to have secured 4 such exceptional speakers who almost need no introduction, but let me start by quickly introduce them. So Professor Guy Goodwin-Gill is Professor of Law at the University of New South Wales. He is also Emeritus Fellow at All Souls College, Oxford. He is, of course, also the founding editor of the International Journal of Refugee Law, and he is also the author of the seminal text, The Refugee in International Law, whose 4th edition will be published in September. Boštjan Zalar is a senior High Court judge in the Croatian High Court. He's also been an ad hoc judge of the European Court of Human Rights since 2010, and he is also president of the Europe chapter of the International Association of Refugee Law and Migration Judges. Since founding the AIRE Centre in 1992, Nuala has been played a colossal role in holding governments to account in countries across Europe. She is currently senior lawyer at the centre and has litigated over 150 cases before the Strasbourg and Luxembourg courts. And finally, but certainly not least, we have Laura Bingham from the Open Society Justice Initiative, a really close collaborator of ENS. And Laura leads their programme on equality and non-discrimination globally, and she's also engineered successful strategic litigation against arbitrary deprivation of nationality in Africa and on citizenship issues in Europe. As well as being having great expertise. All our speakers are also greatly committed. So Nuala is dialing in from a holiday in the Yorkshire Dales. I think it's about 10 or 11 p.m. in Sydney. So Guy, by all rights, should be in bed right now. And Boštjan actually left holiday on an island off Croatia yesterday to be with us here today. But without further ado, let's get started. And we're going to try and run this as a bit of a conversation. So just to say to all participants that please do feel free to pose any questions to the speakers in the chat box, and we'll try to incorporate them time permitting. And if I may, I'd like to sort of set the scene by asking Guy, I mean, this year we celebrate the 60th anniversary of the 1961 Statelessness Convention. Could you tell us a little bit about the origins of that convention, as well as its sister convention, the 1954 Convention on the Status of Stateless Persons? Over to you, Guy.
Right. Yes, thank you very much, Chris. I'm delighted to be participating in this. I must say, I've been involved in one way or another in collecting cases, particularly for refugee status determination, for a long time now, and I'm particularly glad to see the initiative that you've taken on statelessness as well. Many aspects of nationality were, of course, of great interest to states during the League of Nations. Dual nationality was a source of friction. Multiple nationality merely repeated the problems. Nationality of married women raised issues which affected them and also their children, while statelessness was simply anomalous. Now, the International Court of Justice ruled in the Noteboom case that for one state's nationality to be opposable to another state in the context of diplomatic protection, it must satisfy the requirements of international law. It must reflect an effective link, a social fact of attachment between state and individual. At the same time, this sense of nationality needs to be balanced against the socio-political perceptions at particular times. And when one reads the debates in the 1959-1961 conferences, one cannot but be struck by how these issues may transcend purely legal considerations. Let me start with a few words on the 1954 Convention. The July 1951 Conference of Plenipotentiaries on the Refugee Convention was originally intended also to adopt a protocol on stateless persons, but decided that the matter needed more detailed study. A further UN conference then convened in New York and adopted the 1954 Convention relating to the status of stateless persons. Now, this convention parallels that of the Refugee Convention. It deals with status in particular, and it provides for standards of treatment which are contingent on levels of attachment, how connected one is with the state that has recognized one's statelessness. Certain refugee-specific protections are excluded, however, such as non-penalization for illegal entry and non-refoulement. While Article 1 defines a stateless person as a person who is not considered a national by any state under the operation of its law. This has given rise to a rather frustrating debate over the standard proof in applying a definition which, I suggest, was never intended for judicial review, but that's a point we can discuss further later on. Still, the 1954 conference was wary of extending the convention's scope beyond those who might formally be characterized as not possessing a nationality according to law. And it merely recommended that the contracting states should consider sympathetically the situation of those who had valid reasons for rejecting national protection, did not consider process any further. Providing for status is one thing, a good thing, but the main challenge is in eliminating and reducing statelessness. And this is where the 1961 Convention comes in. In July 1951, responding to the technical aspects of statelessness, the International Law Commission appointed Manley Hudson, a US lawyer and former judge of the Permanent Court, as special rapporteur on the study of nationality. Hudson observed that statelessness was undesirable, for every individual should be, as he said, attributed to some state. And it was undesirable also for the individual because of its precariousness. He submitted a paper in which he noted the uniformity of nationality laws, nonetheless, which seemed to indicate a consensus of opinion among states that conferment of nationality at birth should be based on either jus soli or jus sanguinis. or in a combination of these principles. It was open whether state practice had supported an obligation in the matter, but in naturalization, no rules of international law could be deduced other than that they should be a personal or territorial link. Reducing or eliminating statelessness therefore meant attending to causes, and the answer appeared to lie in the adoption of two rules. Firstly, if no other nationality is acquired at birth, the individual should acquire the nationality of the state in whose territory he or she is born. And secondly, loss of nationality after birth should be conditional on the acquisition of another nationality. In 1953, Hudson had resigned for health reasons and been succeeded by Roberta Cordova. The Commission reviewed two draft conventions, one on the elimination, one on the reduction of statelessness. And the following year, after redrafting, it submitted both of these draft conventions to the General Assembly, which decided to convene a conference. The UN Conference on the Elimination or Reduction of Statelessness met first in Geneva in April 1959 and again in New York in 1961, opting to use the draft on the reduction of statelessness as a basis for discussion, basically because it imposed or would impose lesser obligations. And it focused on reducing statelessness at birth. Once again, though, fundamental differences were revealed between those states which favored the principle of jus soli and those which opted for jus sanguinis. No less divisive, though, was the issue of deprivation of nationality. And it was divisions on this issue which necessitated the second session in New York when the final text of the Convention on the Reduction of Statelessness was adopted. And what does the Convention, what does this 1961 Convention do? First, it imposes an obligation on states to grant nationality in certain circumstances. Article 1 provides that, subject to certain reservations, a contracting state, and I quote, shall grant its nationality to a person born in its territory who would otherwise be stateless. Secondly, it settles a variety of what we could call incidental issues, such as the nationality of foundlings, the nationality of those born on ships or on board ships or aircraft, and the nationality of one not born in the territory of a state if one parent had the nationality of that state and the person would otherwise be stateless. Again, subject to certain limitations. Thirdly, loss of nationality on the occasion of a change of civil status or voluntary act of the individual, such as renunciation, was to be conditional on the acquisition of another nationality. And fourthly, it deals with the issue of deprivation. At that time, 1959, 1960, 1961, the United Kingdom drove the debate. It said, to deprive persons of their nationality so as to render them stateless should certainly be an exceptional step. And the freedom of states to deprive persons of their nationality should be severely circumscribed by means of appropriate clauses in the Convention. Article 8 owes much to the UK's initiatives, with a compromise text which admitted no grounds for deprivation other than those already specified in the current law of the contracting states. Article 8 thus freezes the grounds of deprivation. It now lays down the general principle that the state shall not deprive a person of his or her nationality if such deprivation would result in statelessness. However, that duty remains qualified as well, and deprivation of nationality resulting in statelessness is still permitted in the case of naturalized individuals in certain cases. Finally, Article 9 prohibits without exception the deprivation of nationality on racial, ethnic, religious, or political grounds. While in the transfer of territory, Article 10 obliges contracting states to include provisions to ensure that no person becomes stateless as a result. Finally, the UN conference came back to the law-fact distinction, resolving that persons who are stateless de facto should, as far as possible, be treated as stateless de jure to enable them to acquire an effective nationality. But up to now, neither this recommendation nor the similar one attached to the 1954 Convention has proven particularly helpful from a practical perspective. Theoretically, they may encourage states to do a little more than what they have agreed to do, but so far, one can't notice any particular progress in that regard. The reference to effective nationality, however, does recall the thrust of the UK's proposal in 1950, the emphasis on the lack of protection, which it suggested should be the criterion for status. Now, both these conventions have been widely ratified as a result of the efforts of UNHCR over the past 20 years. The 54 Convention has 95 states parties, 1961 has 76. So considerable progress has been made by states in signing on to these documents. What else has been done? A few states, still only a few, have introduced procedures for determination of refugee status, but there is still much work to be done, and it's here that in particular that the case law database will help things. States then, their record at the moment is still patchy. A considerable amount of effort is going to be needed on the part of all of us to push them ahead. Thank you.
Thanks, Guy. And we would certainly echo that there's much more that needs to be done. And thank you very much for giving such a succinct and whistle-stop tour of the international framework. I think we're now going to move to Boštjan to ask him how statelessness has been treated in the jurisprudence of the European Court of Human Rights to date. And in particular, if he could say a few words about the recent landmark ruling in the case of Hoti v. Croatia, and any thoughts you might have, Boštjan, on how the jurisprudence of the court on statelessness might develop in the future.
Thank you, Chris. Well, in the case of Hoti, statelessness is one among the four factual elements behind the reasoning of the Strasbourg Court. In my understanding, statelessness was not the most important element of those four elements. Indeed, one element was general uncertainty of the applicant's situation and impossibility to regularize his residence status in Croatia. And within this element, statelessness was mentioned too. So against that background of the four elements, and not because of statelessness alone, the Strasbourg Court examined the case on the basis of its previous case law related to aliens who, irrespective of many years of actual and tolerated residence in a host country, were not able to regularize their residence status. Cases of this kind involve positive obligations under Article 8 of the European Convention on Human Rights. And on this point, in further paragraphs of the Hoti judgment, the Grand Chamber judgment in the case of Kuric and others versus Slovenia, which by the way is my country, is used several times, perhaps because the court considered that the fact that Mr. Hoti was stateless, while some applicants in Kuric's case were not stateless, was not the essential difference between the two cases. Litigation before the Strasbourg Court did not end statelessness in this case. So it is essential in general, not just in the case of Hoti, that policies of the contracting states follow judgment such as Hoti, where the Strasbourg Court found violation of the protection of private life because positive obligations from Article 8 of the European Convention were not taken into account. By which particular mean, by which kind of permit or legal status the contracting state will end the situation of uncertainty and interference in private life is a matter of choice of the contracting state. It is very much so under the existing case law. Unfortunately, in such cases, the Strasbourg Court cannot even get to a substantial adjudication whether the fair balance was struck between the general interest and the interest of the individual for which the state enjoys a certain margin of appreciation. In those cases, judicial control of the Strasbourg Court usually ends already on a very basic and elementary procedural question where the state authorities, including courts, provided an effective and accessible procedure enabling the applicant to have his stay and status in that country determined with due regard to his private life interests. But there is a value added of Hoti in comparison to Kuric and others versus Slovenia. The Strasbourg Court, in the case of Hoti, decided that based on the convention relating to the status of stateless persons, the contracting states must consider taking relevant measures ex officio, for example, to provide administrative assistance to facilitate the applicant's contact with authorities of another country to resolve the applicant's situation. And a similar pattern of reasoning can be found in the older case of Kim versus Russia from 2014, which relate to vulnerable situation of stateless applicant and the length of his detention. And this can be compared also with the Kaldor judgment of the Court of Justice of the European Union. These are all judgments in your database. It is worth to mention that in the Grand Chamber judgment in the case of Kuric from 2012, in its decision on non-admissibility of the application of stateless applicant Mr. Dabetic, his statelessness did not play any role at all. Similarly, in the case of applicant Mr. Kuric, his statelessness was not mentioned, only general vulnerability and legal insecurity were mentioned. Therefore, in the case of Hoti, the small chamber of the Strasbourg Court went further from the Grand Chamber judgment in the case of Kuric as regards dealing with statelessness. Interestingly, in the small chamber judgment in the case of Kuric, the Strasbourg Court found violation of Article 8 of the European Convention also in the light of relevant international law standards aimed at the avoidance of statelessness, especially in situations of state succession. And that is why I see Hoti as a step further as regards avoidance of statelessness. The later case of Sudita Keita versus Hungary from May 2020 proves that, since here the small chamber builds further based on Hoti judgment, and statelessness here is expressly recognized as a very important element for finding violation of Article 8 of the European Convention. So how do I see the jurisprudence of the court developing in the future? Well, it might be the case that the court will apply stricter tests for checking whether domestic law was fully respected, and perhaps in the next step, more international law references on avoidance of statelessness will be integrated in its interpretation, so that the closer link will be established between personal identity from Article 8 of the European Convention and citizenship. Back to you, Chris.
Thank you, Boštjan, for such a quick and comprehensive tour of the Strasbourg jurisprudence. And like you, we're also encouraged by Hoti as a step forward. And to our mind, it potentially sort of lays the seeds for the court to develop the idea of a stateless migrant as a special category of rights holder. But in relation to the sort of the judgments, all the judgments you mentioned, also Kuric and Kim and others, just to ask you, why are these judgments, relevant and important for judges in your country, Slovenia, and across the Balkans, but also across Europe more generally?
Well, to put it simply, these judgments are relevant for judges because this is law. Perhaps the more relevant question for us would be why this kind of violations happen too often. Why do we not learn out of our mistakes? As I see this problem, the answer is again very simple. There is a lack of understanding of the importance of the separation of powers and judicial independence, especially when general principles of law and international law are involved in administrative disputes. Selection, appointment, and promotion of judges should be based on transparent, rigorous, and meritocratic criteria. In my region, this is a problem. The Luxembourg Court rightly stated in one of the recent judgments concerning the rule of law problems in Central and Eastern Europe that for the effective implementation of the European law, the Supreme Courts are the most important. And our case, Kuric versus Slovenia, proves that. Furthermore, in the region, case law of the Strasbourg Court is not used as a tool to build sustainable quality of adjudication. Case law of the Strasbourg Court is not integrated in total quality management in judiciary, and this includes the system of performance evaluation of judges. Initial and continuous training of judges should be improved, particularly in the field of human rights law. But again, this should be done based on meritocratic principles about how training programs should be drafted and how speakers should be selected. There is also a more specific answer to the question why this kind of violations, including the right to private life in the context of statelessness, occur so often. It is very typical that when contracting states regulate some kind of discretionary power in their national law, or if discretion is regulated in the secondary EU law, that discretion is rarely exercised by authorities, and it is rarely controlled by courts, while taking into account at the same time also human rights law. And this combination of a discretion and applicability of human rights is a problem, which is not relevant only in Central and Eastern Europe. The good example of this is a discretionary clause under Article 17 of the Dublin regulation, or the ambiguous use of the principle of the best interest of a child in court practices. But let's be optimistic. In the past 3 years, the very important precedents have been adopted by the Luxembourg and the Strasbourg Court concerning the rule of law, judicial independence, including appointment of judges, starting with the judgment in February 2018 in respect of judges in Portugal, and not to mention the extremely important judgment in the case of judges in Iceland from December 2020. So I hope that judicial councils in Europe will study thoroughly relevant judgments, perhaps around 20 relevant judgments from the last 3.5 years. So the Judicial Council and other authorities will start using these new qualitative criteria for judicial independence and the right to court established by law, which include meritocratic selection criteria in domestic systems of administration of justice. And that would turn the actual situation into something much better in the longer run. Thank you very much.
Thank you, Boštjan. And you make many important observations, including about the rule of law and the implementation of judges. And as a network, our strategy is very much not only to try to influence regional courts, but through our members at country level to try and ensure the effective implementation of judgments. I would like to turn to Nuala now, who I think offers a unique perspective as someone who's litigated before national and regional courts over several decades, to ask Nuala, what opportunities you see for lawyers to further the protection of the rights of stateless people across Europe.
Thank you very much, Chris. I just wanted to say that I think litigating these issues will have been enormously assisted by the wonderful work that you have done in creating this database. Because the first thing any lawyer has to do, apart from checking the facts, and we'll come to that in a minute, the first thing any lawyer has to do is to make sure that before they go into a case litigating against a government, and often a very powerful government, the first thing they have to do is to make sure that they have all the tools that they need at their disposal. And lawyers who are litigating statelessness issues could have spent hours trying to locate all the decisions that you have assembled here, so that they are now able to single source which is there for them to reach. And I think that that's extremely important for who want to litigate this at their disposal.
Nuala, sorry to interrupt. I think I know your connection's a bit unstable, so you might need to switch your camera off.
If they're litigating these issues. Can you hear?
We can hear you, Nuala, but the connection's a bit unstable, so you might wish to switch your camera off. Thank you.
I've turned my camera off. Does that make it better?
That makes it much better. Great, thanks.
Yes. Good. It's no loss to anyone not to be able to see my face. I think the important thing is that when you're going to litigate in international tribunals, you normally have to, and something that people very often forget is the importance of raising issues in the national court if they're going to want to raise them later in Luxembourg or Strasbourg, being the typical destinations for those of us in Europe. And it's very hard if nobody has talked, for example, about the rights of the affected children in the national litigation, then to bring this up as an issue in Luxembourg or Strasbourg. So I think it's very important that it's realized. I also think we have to be a little bit creative about understanding the importance of statelessness. The European Court, as Boštjan has made clear, the Court of Human Rights has managed to introduce statelessness into the convention in a way that it wasn't there before by that much used mechanism of making it a part of the private life rubric of Article 8 of the ECHR. But we also have other instruments, for example, not just the two statelessness conventions that Guy described so clearly, but we also have the issues of the Convention on the Rights of the Child, for example, in Article 7, and the right of children to their identity and their cultural identity. And I think it's very important. When I was thinking about what I was going to say to you today and was discussing with some of the wonderful interns who work with us, I went back, as Guy did just earlier, went to the Notterboom case and to start thinking about what the attachment theory is in the Notterboom case, and whether or not we should start going back to thinking about the attachment in the Notterboom case if we're thinking of litigating these issues. But there is a point that I do want to make, which is the mantra I have been chanting for years, which is bad facts make bad law. And it's really important to ensure that you have a solid factual basis for a case that you are going to litigate before you start litigating it, because it's no good using your wonderful database to perfect jurisprudential arguments if the bottom falls out of your case because you haven't verified the facts. We might come on to that later today, but those are just the points that I want to make now to introduce the whole question of litigation. Thank you.
Thanks, Nuala, for the typically valuable insights and so much food for thought. And you know, for us as a network, our strategic partnership on litigation with the AIRE Centre is a big part of our plans going forward. So thank you also for that. I guess linked to that, one case which has been receiving a lot of attention in the UK is that of Shamima Begum, and ENS and the AIRE Centre recently jointly intervened before the Strasbourg court in the case of FAM v UK, which also concerns deprivation of nationality. So could you tell us a little bit about the principles and issues at stake in this type of case, and perhaps particularly any particular implications for children?
Well, the sad thing about the Shamima Begum case, and perhaps for the benefit of our 325 listeners who may not be familiar with its details, Shamima Begum was a child who was groomed and went off with a couple of friends to become an ISIS bride to join ISIS in Syria. She has been going through considerable litigation ever since, and the latest part of that litigation is raising the issues about her being a victim of trafficking. And of course, if she was a victim of trafficking, then it's extremely important that under Article 4 of the Council of Europe Trafficking Convention, the fact that she appeared to go willingly is of no importance whatever, because she was a child at the time. And Shamima Begum was deprived of her citizenship because she was held to be a risk to national security, with the express intention of preventing her from returning to the UK. Because in order to prevent her from returning to the UK, she had to be deprived of her citizenship. At one point, when she still had one of her children alive, it seems that it might be possible for the child to come back. And indeed, the British have brought back a number of orphaned children of ISIS brides from Syria, but they have only brought them back if their mothers were dead or disappeared. They will not allow parents to come back with them. And the problem with many families, many British children, because of course the children can't be deprived of their nationality because they lack the capacity, I think, these very, very young children to form the mens rea that would make them a terrorist threat. But they can't come back because the Kurdish authorities who are running the camps have, for very good reasons, don't want to split families. They don't want to split mothers from very small children. So they won't let the children go back to the UK, where they could go live with their grandparents, unless the British will let the mothers go with them. So we have a very, very complex scenario here about what happens if you've got mothers who have been deprived of their citizenship, and sometimes the fathers too, and they're there with children who have not been deprived of their citizenship. And I know that Guy may burst a blood vessel if I use the word de facto stateless, because I have seen him react hideously to the idea that there's de facto statelessness rather than legal statelessness before. But I think it's very important that these children are rendered de facto stateless, as it were. And it's very interesting because, you know, what attaches to your citizenship is something that has been hallowed by history. Everybody knows about civis Romanus sum. Some of us are old enough to have had a Latin textbook that was called civis Romanus sum. I am a Roman citizen, and St. Paul famously couldn't be crucified because he was a Roman citizen. He had to have the much less degrading death penalty of decapitation, but he couldn't be crucified because he was a Roman citizen. And in the middle of the 19th century in Greece, and I'm sure our colleague Patricia here will know the story of Dom Pacifico, who was actually Portuguese, but a British subject. And he was the person who was being degraded in Athens in the middle of the 19th century. And Lord Palmerston importantly intervened and said, civis Britannicus sum. I am a British citizen and I have to be protected from all harm because of this. And we seem to have forgotten that when we're looking at depriving British citizens of that status by a mechanism which is wholly inappropriate, because it would be far more appropriate to deal with those who had been groomed to go to Syria by some other mechanism, but not to deprive them of their citizenship. And we can perhaps come on later to the mantra that's very often repeated by the British, certainly in two cases in Luxembourg, in Core and in Micheletti. The British joined with other governments to say very firmly, the only people who can decide if someone is their citizen is that state itself. And yet we find in the British Nationality Act, the 44, that the British can say, well, they can decide that somebody isn't going to be stateless if they're deprived of their citizenship, because we, the British, have decided that they could get another citizenship. And that's entirely contrary to everybody else's view. So I think these are just a few issues that we point, because I've gone long over my 2 minutes.
Thank you, Nuala, I'm sure we could go on, talk for several hours about this. And I'm also glad to see that Guy's blood vessels, I think, still look intact. But in terms of the subject of deprivation of nationality, I mean, next week we have another event where we're launching our statelessness index briefing on deprivation as it results in statelessness. So anyone interested can tune in for that event next Thursday. I would like to now move the mic to Laura. In terms of saying that we were all hugely encouraged to see the Denny judgment from the Human Rights Committee earlier this year. So could you tell us a little bit about that judgment and its implications for the protection of stateless children in Europe and indeed globally?
Sure, thanks, Chris, and thank you so much for convening this panel and for putting together the fabulous case law database. I hope I can be brief also because my illustrious co-panelists have done such a fabulous job of setting out some of the frameworks that I might mention talking about this judgment. But just, one reflection quickly, because I'm going to talk about a case that we took from the Netherlands with Dutch counsel to the Human Rights Committee, which takes us sort of zooming out outside of the context of Europe. But it's very much in order to, as Guy and Boštjan referred to specifically, in order to call on the protections that European states have signed on to provide under the European Convention on Human Rights, under the 1954 and 1961 conventions. But the child at the center of this case, Denny Zhao, was left still without protection, even in spite of those legal obligations. So the litigation in this case is really about making the protections real in everyday life. And I think that that's what a case law database as a tool for litigators and others who are seeking access to justice is really for. It's not only a static kind of a way of finding the law, it's also a way of tracking the progressive development of the law. So just briefly, this case is about, it centers on Article 24.3 of the Covenant on Civil and Political Rights, which guarantees the child's right to acquire a nationality. The case itself is quite complex because of the complex registration and nationality laws at play in the Netherlands. And that was one aspect of the facts, just to point to what Nuala was saying about, bad facts, big bad law, but also in many statelessness cases, even if you meticulously document the facts, they're always incredibly complex cases because law tends to, at the national level, not really recognize the condition of statelessness. It's not built around stateless people. It's almost willfully blind to their existence. And that's what happened to our client in this case. He first and foremost couldn't register as stateless. He couldn't, and his mother was unable to show sufficient proof, just back to this question of the burden of proof and standards of proof under the 1954 definition. There was no mechanism in the Netherlands. There's no status determination procedure. So really, our client and his mother were just going to registration authorities and trying to have an administrative notation to say that he was stateless as a first step. And they were unable to do that for a variety of reasons. That prevented him, in some sense, from having a further ability to show that under the 1961 convention, he ought to acquire nationality as a child who was born stateless in the Netherlands because of that obligation. So he couldn't exercise it. Furthermore, the Netherlands has a requirement of lawful residency before a child who might be entitled to the 1961 protection can even qualify. And so he had this stack of obligations that he was facing. And our concern when we were documenting these facts was really that when it went before the committee, even though this is a human rights body, and there's a particular clause, a provision that's should directly be applicable to the situation of a lack of protection, it might be simply too complex for the committee to really be able to reach that. And we weren't sure that the committee would call for general remedies, to call for the kinds of remedies that would actually provide a solution for the client in this case, for the child Denny Zhao. The reason why, or one of the reasons why I think the case is really significant is because the committee did find that general remedial measures were required. It also required the Netherlands, in finding a violation of Article 24.3, to take steps within the context of Denny's particular case to address his living situation, not only his legal situation, because since he was out of status, since he had an irregular status, he was living in a center that restricts freedom, restricted his personal development, and he wasn't really able to live his life, even though he had these protections that ought to be guaranteed to him. So across the individual and general remedies that were ordered in this case, you can see a human rights lens on what some of the pre-existing obligations ought to look like, what they ought to require states to do as a positive, progressive realization of the rights of stateless children. So I guess the last piece really is that the reason this case is significant more broadly across the globe is that it applies to other states that have ratified the ICCPR, the covenant, and have these obligations under Article 24.3. So in a sense, I think, and this takes us back to the case law database and the purpose of documenting these cases and their meaning and showing them in relation to one another, it creates more sort of trans-regional and global solidarity in the legal community that is working to eradicate statelessness and bring about real protections for people who are living with statelessness. And that, I think, just the final word shows through in the Human Rights Committee's decision, if you read it, and I think we can put the link in the chat if we haven't already, because the committee did cite to jurisprudence from the African system. It cited to UNHCR guidance on how the 1954 and 1961 convention provisions should be interpreted. And so you already see this knitting together of the progressive development of jurisprudence and legal commentary in the decision itself.
Thanks, Laura. And I think that sort of cross-fertilization of regional work is going to be really important in the future. And also, such an important judgment and a really, vital fillip for us about why we should persist. And, I guess the positive outcome, very much came about because of the persistence of OSJI and your partners in the Netherlands. So I guess to ask, what lessons were learned about how to sort of galvanize and support that type of initiative, and what ancillary activities were necessary to enable effective strategic litigation?
And I'll be really brief, just so that we might have some time to get to questions. So I think I would flip the script a little bit on your question, Chris, because really this case emerged from advocacy at the national level, and it was fully integrated into that advocacy. And I think that's a key point about strategic litigation, is that it needs to be nested within a broader set of actions that are engaging government and engaging civil society to push forward for reforms that ultimately need to come at national level, need to come through legal frameworks. And so, we can achieve certain impacts with a case like this. The committee's recommendations are non-binding, for example, but it has an important story to tell. It puts a particular normative framework around what the obligations dictate, but that needs to go back into this community that had already done mapping, that had taken, as Nuala said, had taken the case up through the courts in the national level, and that's engaging with a process right now in the legislature to enact these laws. So there is a draft bill and there's a lot of engagement going on. And this case is just one piece of that.
Thanks, Laura. And yes, I am conscious of time. We have 5 minutes left on the clock, but I'm going to pray the indulgence of participants that we could go on for at least an extra 5 minutes, which would allow us, 10 minutes for a final round of interventions from our speakers. But I would ask if all speakers could keep that to strictly 2 minutes each. And actually, if I may, I'll continue with Laura just to slightly build on your last point that, obviously, partnership and networking is critical to effective strategic litigation. So in your view, how could our database, help sort of engage a wider spectrum of lawyers, including, for example, through pro bono partnerships, law clinics or paralegal, community paralegal projects?
Sure, yeah. So, I think the case law database, well, for one thing, it gives the legal community and the broader access to justice community around this issue, or that encounters this issue, a sense of identity and connectedness. And I think, that is not there without a tool like this. So you can find, I think lawyers, legal advocates know that there are people behind these cases. And when you see it, when you find a case that will help, or that you're interested in learning more about, automatically you know that you can connect with the people who are behind that case. It builds a community. I mean, I think in terms of pro bono support as well, this is a key tool also for stateless people who are looking for good legal counsel. And often, with those resources, the case law database can help to build more of a practice, to inculcate sort of more knowledge within law firms, more of a concerted sort of defined practice area. And again, I think it's about interconnectedness. And I guess the last thing that I would say is that, we've seen stateless people as advocates in their own cause, and coming up, forming organizations, mobilizing more and more and more, which is really critical from a strategic standpoint. And they need this tool to be able to sort of unpick legal arguments, to understand their own cases, to connect with each other. So I think for the communities who aren't legal actors, who aren't litigators themselves, it's really important to have this tool as well, because it is a very complex, legally sort of infused issue. So being able to unpick that and understand it is important, more than for just legal representatives and litigators.
Thank you, Laura. I'm going to turn to Guy now. I mean, I'm personally, dying to read the next edition, including which will have a chapter on statelessness. And I was interested to ask, how you see the nexus between statelessness and forced migration, and how the database could be relevant for refugee lawyers across Europe and globally. So comment on that if you wish, but equally feel free to pick up any other points you'd like to in your final 2 minutes. Thanks, Guy.
I'm glad to say that every case that's been mentioned today figures in Chapter 13 of the new edition of the Refugee and International Law out in September, which is good. Particularly as I think there's no major divergence between the authors and those commentators who have contributed this evening. I want to support what Laura said about the involvement of civil society, though, because in refugee law and clearly in statelessness law, there's been no progressive development without the involvement of civil society. It is critically important. The 51 Convention is the most litigated treaty in the world, and I'm pretty sure that the 1954 Convention will soon be up there with it as well. So I think to bring in civil society and to have them involved with particular cases is very important, not only to the individuals themselves, but to the wider understanding of the issues. So that's good. Nonetheless, there are challenges ahead, as we know, and I've forgotten your question already, so I think I'm going to leave it there.
Thanks, Guy, and you actually you answered it, and just to echo the point, and we're very grateful to have really key academics such as you within our membership, helping to make those linkages between civil society and academia, which is greatly appreciated. Also, in terms of developing new arguments, and I think the standard of proof is definitely something we'd like to pick your brains on when we have a bit more time. I guess
to deal with in some detail, it does need another meeting, I'm afraid. Yes.
Yes, exactly. But I would like to turn to Boštjan now. I mean, Boštjan, in your role as president of the Europe chapter of the IMRMJ, and as someone who's always keenly advocated the importance of information and training among lawyers, among judges from different jurisdictions, could you maybe comment on how the database could be integrated into those efforts, or anything else you'd like to say in your final remarks?
Well, thank you. I would mention that based on the contract with the European Asylum Support Office, during the last 6 years, the International Association of Refugee and Migration Judges, that is the European chapter, has drafted 5 judicial analysis as training materials for judges for all major chapters of the Common European Asylum System. And these judicial analyses are designed by judges for judges. The issue of statelessness has got less than 1 page of space in the judicial analysis on qualification for international protection, which was published in 2016. And then there are 5 pages on statelessness in our judicial analysis on evidence and credibility assessment. Courts in asylum disputes do not have jurisdiction to decide the nationality of the applicant. However, by granting a refugee status or subsidiary protection, judges or decision makers do resolve the problems of de facto stateless persons, because several important civil, economic, and social rights derive out of refugee status or subsidiary protection. No question for a preliminary ruling was asked so far by national judges on the issue of statelessness in the context of material and procedural refugee law. But I would like to mention the preliminary ruling in the case of OA, which is not in your database, from January this year, where the Luxembourg court rejected the view of the courts in the United Kingdom and decided that social and financial support provided by the family or clan cannot be relevant in respect of the question whether effective protection is available in the country of origin in case of return, and also cannot be relevant in respect of the assessment of well-founded fear of being persecuted. The European chapter of RMJ is now in the middle of updating and reviewing judicial analysis on qualification for international protection from 2016 and judicial analysis on evidence assessment and credibility. I doubt that we have anything substantial to add to these first editions of the judicial analysis, except some national case law that we now have in your database. And I already checked some of those national judgments. Perhaps in the field of migration, there is more things to discuss about statelessness within our association, as this is the case in the field of refugee law. And for that purpose, the Hoti judgment will certainly be on our agenda, as well as Sudita Keta versus Hungary. Back to you, Chris.
Thanks, Boštjan, and we would certainly take up that invitation to stay in touch with you and your judicial colleagues going forward. So Nuala, you have the final word, or perhaps the penultimate word, as I would do a quick closing after you. But yeah, again, given your experience, and you touched on it earlier, just how you think the database can be used, and any other final observations.
Thank you very much. I think one of the things that we tried to make clear in our joint intervention with you in the FAM case that it's a question of having proper procedural safeguards when anybody is, when there is a proposal to deprive someone of statelessness. And I'm sorry if I'm straying into next week's work, but I think it will always overlap to a certain extent. The whole point about deciding to deprive someone of their statelessness, you don't deprive them of their citizenship and then check and see if they have a citizenship of another country. First, you have to check and see if they have a citizenship of another country. And as I pointed out earlier, the British government has always been in the forefront of litigating in both Strasbourg and Luxembourg, that the only people who can decide whether or not somebody is a citizen of a country is that country itself. So the first thing you have to do is establish that somebody has another citizenship. And only then can you decide whether or not it would be lawful to deprive them of the citizenship that you want to, the government want to deprive them of. And that's why I think from the British perspective and from the terrible
Nuala, we just lost your connection.
From section 40 of the, can you hear me now?
You might want to switch the camera off.
Yeah, I'll switch the camera off. Can you hear me now? Can you hear me better now? I think it's where the Secretary, what they say in that provision is if the Secretary of State has reasonable grounds for believing that the person is able to become a national of such a country or territory. And that's where I think the real problem lies, because I think we have to make it absolutely clear that before you deprive someone of one citizenship, it has to be absolutely crystal clear and undisputed, as it was in the case of Shamima Begum, undisputed that they have another citizenship. And that, I think, is extremely important. And as Guy said right at the beginning, international law does not like statelessness, quite apart from humane attitudes to the people who are victims of statelessness. But international law is untidy because it means you have a person in a country who is not a citizen of that country and not a citizen of anywhere else. And according to international law principles, the responsibility for that person is deeply weakened. That's what I think is very important. And I hope that we are able to use your database to take forward litigating to reduce the deprivation of citizenship, and even more importantly, not to violate the provisions of the Convention on the Rights of the Child, so as to render children who have not been deprived of their citizenship unable to enter the countries of their nationalities. Thank you.
Thank you, Nuala. And I think we would all echo all of that. But with regard to the main point you were making, also just to direct people to the joint intervention, which ENS did with the AIRE Centre in the case of FAM, which outlines in more detail some of those principles. We are, I'm afraid, out of time. I for one, and apologies for that to everyone, but I for one have been spending a lot of time on Zoom, but most of it didn't feel as productive as the last hour and 9 minutes. So I want to say a huge thank you to our speakers, obviously, but also again to all our members and partners who helped us develop the database, and to all of you who've joined the event today. And really just to echo that, as I said at the beginning, we very much see the database as a public good, a collaborative venture. So we are going to rely on our members and partners contributing case summaries, but we also invite everyone who's dialed in to get in touch if they would like to contribute case summaries. And that will help us to grow the database and make it more effective as a catalyst for strategic litigation. I was going to say a bit more in closing, but there isn't time. But I do just want to mention that after I finish speaking, my colleague Jan will put up a short video with sort of a quick tour of the database and a link in case people want to go and check it out after this meeting. And in conclusion, I would just say, you know, please do use the database, please contribute to the database, and together we really can make a difference. Thank you, everyone.